And now I will introduce today's speakers. We are very pleased to welcome Elizabeth McAdams of Aon Corporation to speak on our panel today. With its global headquarters in London and North American headquarters in Chicago, Aon is a leading global professional services firm providing a broad range of risk, retirement, and health solutions with over 66,000 employees across the globe. Elizabeth serves as Senior Manager, Global Immigration, where she oversees the company's immigration strategy, processing, and compliance for foreign national employees located in more than 150 countries. Prior to joining Aon, she worked at a Chicago-based financial software company and at law firms where she specialized in business immigration. Eric Ledbetter and Maria Kallmeyer are partners in the immigration law group at Quarles and Brady. Established in the 1970s, Quarles and Brady's immigration law group is national in scope, spanning across the country from Washington, D.C. in the east to our Phoenix office in the west. There are approximately 30 full-time dedicated professionals in the group, including partners, associates, paralegals, and legal project assistants. The immigration law group practices before all the immigration-related government agencies and administrative courts, supports clients at U.S. consulates in every country in the world. The partners who make up the group serve with the American Immigration Lawyers Association on national and local committees to build and strengthen ties with the various immigration agencies. Together, they bring in-depth expertise and practical knowledge about all the employment-based immigration compliance matters. With that, I'll turn it over to Eric.
Okay, thank you, Kathleen, for that introduction, and thank you everyone for coming to our webinar and our seminar today. We really appreciate that you came out to listen to us talk about immigration for an hour. If you have any questions today, here in the Chicago office, just raise your hand. We're happy to take it, or you can jot your question down. We will do questions and answers at the end, but we'll also take questions all throughout. If you're on the webinar, again, you can type your question in. And if you're in one of the other offices, just find the administrator and ask your question that way. If we're not able to get to all the questions during the session, we will reach out to people afterwards with responses. So we thought we would start with sort of an outline of the legal framework for immigration, because these days we get a lot of questions about people trying to understand what can we count on, what's set in stone, what's takes an act of Congress to change versus what can be changed overnight by a presidential directive or an agency memo. And so I tend to think of the legal framework as being in four parts. The first part at the top would be an act of Congress. So anytime Congress passes a law bearing on immigration, that then goes into the Immigration and Nationality Act. And the Immigration and Nationality Act is housed at Title 8 in the U.S. Code and has been with us since I think probably the founding of the Republic, going all the way back to the Alien and Sedition Act. And so like any other federal law, that requires, Congress passes a law and the president signs it, or Congress overrides a veto. Beneath that, then we have the implementing regulations, which are written regulations. This happens all within the executive branch, and yet it's a very formal, usually lengthy process. The way it works is an agency, like in this case, the Department of Homeland Security, would write a draft regulation and introduce that to the public through the Federal Register. And then there would be a period of notice and comment. People write, lawyers, law firms, organizations, write very extensive comments, then usually numbering into the tens of thousands. The agency then will grapple with all those comments and then finalize a regulation and publish it, and it becomes part of the Code of Federal Regulations with an effective date. Written regulations, like laws, can give and also take away substantive rights. So as an example, a couple of years ago, H-4 visa holders, those are spouses of H-1B visa holders, were given the right to get a work permit under certain limited situations. And so that was granted to them through regulation and could be taken away from them by regulation. And so, regulations are formal, they're broad-based, and they can affect substantive rights. Beneath that, then we have executive orders, or also agency memos, cables, State Department guidance that goes out to all the various consulates. These are usually broad-based, but they reflect procedural changes, not so much substantive rights. But of course, we know if you change the procedure, you might have an effect on somebody's rights. If you change the procedure in a way that causes things to take a long time or interprets a phrase in a legal statute in a different way, that might have an effect on substantive rights. But it's supposed to be focused on process. And then finally, we have just the kind of never-ending constant change that occurs at the agencies that we practiced before. And that can be just because one agency, one office within an agency might just decide to start emphasizing some issue more than another issue. There can be variations between officers. We want all the officers on a line to think and do things in the same way, but we're dealing with people, and so that doesn't really happen. So an officer could come in the morning and say, well, you know, I was reading this presidential executive order, and I think that means I should focus more on this issue. And so sometimes that's a training issue, and other times it's just the natural variation between different people. We also see that at the consulates. For instance, a consulate in London will have different priorities, different goals, a different outlook from a consulate, say, in Mexico City or Beijing, China. And because of the difference in relationships between our country and the other country, that sort of filters its way into the consulate and will have an effect on how they view their tasks. So although all consulates are processing the same visa types, they just might approach it in a different way. And that could be, again, at the officer level, or it could be more by design at the management level. So that's a framework I want people to be able to think about today as we're going through all the changes that we've seen in 2017 and what we're likely to see in 2018. And as we're talking about these things, maybe just sort of think, is that a law or is that a regulation? How set in stone is this? One thing I should also add is treaties, which is not on there. Typically what happens when a treaty gets negotiated and ratified is then Congress passes that into law. And so we would think of it normally as being in the first bullet, but we know there's precedent for presidents pulling out of treaties unilaterally without congressional input. And then the Supreme Court has tended not to want to adjudicate those cases. So for instance, with NAFTA, if suddenly we were just no longer in NAFTA, that would call into question the visas for Canadians and Mexicans that arise under NAFTA. And so that might be sort of something that goes around what the first bullet says in under federal statutes. But so I also want to say before we get too far into this, this is a seminar on business immigration. So that's what we're going to focus on. The field of immigration as a whole is vast, and we're just going to talk about our little piece of it, and that's vast enough for us. And also we're going to assume that people have some level of knowledge, but we won't leave you hanging. We'll try to make sure we're clarifying and explaining as we go, but we are going to summarize what happened in 2017. And so just by virtue of that, we probably will get a little into the weeds. And so with that, I'm going to turn it over to Maria, who will talk about some of the things that happened in the first part of 2017.
Thanks, Eric. So to start out the year, we actually had a new regulation. It was a highly skilled worker regulation. Something that the immigration community has been waiting for a long time, 10 years. It actually mainly happened under the previous administration, because it was a regulation the previous administration had spent a couple years talking to stakeholders and really looking into the issues and figuring out what would be the best way to come forward with the regulation. And then, of course, there was a formal notice and comment period as well. And it became effective on January 17th. I think we would have been talking about it a lot in January and February, except that so many other things happened in immigration at that time within the administration, so this one didn't get talked about as much as it probably should have. One of the big things that happened under the new regulation was a new rule for H-1B CAP exemption based on affiliation. This was a really big deal in the physician immigration world. Any nonprofit organizations that were affiliated or are affiliated with institutions of higher education. The big pro of the new rule was that it is far more broad than the old rule. the new rule is that you have to get an H-1B cap exemption, you have to be a nonprofit, you have to be affiliated with an institution of higher education, and you have to have a fundamental activity, just one fundamental activity of your organization has to be to contribute to the same educational or research mission of the university. So there are other reasons that you can get an H-1B cap exemption, but this is one of them that changed, and it was and still is a really big deal. The con with it is that before this new rule came into place, there was a deference memo. So if your organization had an H-1B that was cap exempt before 2011, after that they were able to get that cap exemption for other H-1B petitions. Now there is not deference anymore, so each petition is adjudicated on its own merit, and so we have to reprove every single case. And we're doing that under the new administration. So I would say in practice, that's mostly been a positive change, but we have seen a lot of requests for evidence and a lot of need to really prove the rule and show how the organization is exempt and affiliated.
Maria, can you pull the microphone closer to you?
Yep, is
Thank
that
you.
better? Okay. So the other thing that happened under this new regulation was that it called for automatic EAD extensions. EAD stands for Employment Authorization Card. There are many categories in which an individual can get an employment authorization card. One of the big categories that we see a lot is if you're in the green card process and you filed an I-45 application, you can get a temporary employment authorization card in the meantime. So this regulation calls for automatic extensions of those employment authorization cards in some categories, but not all. So it was really great for those categories that do get the automatic extensions, because you can get an automatic extension and don't have to worry about filing your employment authorization card in time. For employers, it's also something new, a new document that you'll see for I-9 verification. You used to not be able to use an employment authorization card receipt notice. Now you can use that for I-9 purposes in certain circumstances, but it has to be in the right category. But the con, or the thing to watch for there, is that it's not in all categories. So if you have a L2 or an H4 EAD, for example, you need to make sure that those are filed even earlier to ensure that they are approved before they expire, because the processing times are no longer. The other thing it created was a 60-day grace period after termination for H-1B. So it used to be that when an H-1B was terminated. All right, I have a new microphone now. Hopefully that's better. So in the past, when an H-1B was terminated, they were expected to leave the country immediately upon termination. Now there is a 60-day grace period that allows them to stay in the U.S. and look for new employment. One of the things, there's really two things to keep in mind about that 60-day grace period. One is that it's discretionary, so it needs to be approved with a new petition. The regulation actually says that USCIS may approve it for a grace period. So in practice, it's been applied liberally, which is great, but people shouldn't assume that H-1B visa holders shouldn't assume that they can just quit one job and take a vacation for 60 days and that they'll be fine when they get a new one, because it is discretionary and has to be approved in every single case. And finally, it also added a 10-day grace period in most non-immigrant categories. So in practice, what we're seeing here is approval notices coming from USCIS are approved for a certain period of time, but then on the I-94, they're getting an additional 10 days. So for example, if someone has an H-1B petition for a 3-year period, this new regulation gives them an extra 10 days to stay in the U.S. after the 3-year period. And Elizabeth, I was wondering if you could help us out and tell us a little bit of, practical things that you've seen at AON with respect to this new regulation.
Yeah, mostly what we are finding is just jumping ahead on that L2 H4 EADs. tracking and monitoring it and starting those renewals a little bit earlier than you normally would. In the past, I think we were starting maybe at 4 months, and now we're looking at 6 months. So in just tightening up your organization and looking at the expiration dates a little bit closer, making sure that there's no gap in authorization, because that can cause a lot of business disruption if someone has to stop working for a little bit.
Right. Okay, and I think that 60-day grace period is also great to keep in mind, both when you're terminating an H-1B and when you're hiring a new one. For hires, it's great because if you find somebody who's been terminated for a prior employer, in the past they had to leave and re-enter on your new H-1B. Now, if it's been less than 60 days, you can just file a change of employer petition and they don't have to leave, which is great. And for terminations, I guess you can be less concerned about their well-being because they have that 60 days to figure it out. Okay, so moving on, the next thing that happened in 2017 is something that I'm sure everybody has heard about. Right out of the gate, the Trump administration issued a bunch of immigration orders and presidential proclamations, really outlining what the immigration agenda was going to be for this administration. The first one was the travel ban, and I'm not going to get too much into the weeds and talk about the details of any of these orders because I think everybody knows about all of them by now. But what I am going to talk about is sort of where they stand now and what can we expect in the future. What have we seen happen in the rest of the year as a result of these orders? So the first one, the travel ban order, on September 24th, the president came out with a presidential proclamation issued with specific and different requirements for 8 countries. So this was a result of the studies that they did as a result of the initial executive orders. So the new 8 countries are Chad, Iran, Libya, North Korea, Somalia, Syria, Venezuela, and Yemen. This new proclamation was expected to go into effect on October 18th, but then on October 17th, it was blocked by 2 district court judges. So right now it is still blocked. But just to give you a few more details about it in case that changes, it doesn't apply to permanent residents. It mostly applies to individuals who are outside the U.S. on the effective date and don't have a valid visa. So I don't think we need to worry too much about people who are currently here in the U.S. and may already be your employees. But to the extent that you would be considering hiring someone who's from one of these countries and they're currently not in the U.S., I do think you should be concerned about the extent of time it might take to actually get them a visa to come into the U.S. And Eric will talk more about that in the Department of State section about extreme vetting. The third, I call this travel ban 3.0 because it's the third version. It is an indefinite ban. The other ones had a time period. This is an indefinite ban, but federal agencies are supposed to review it and assess whether it's working and how to move forward every 180 days. It also did not, excuse me, doesn't impose restrictions on refugees, but refugee admissions were halted through October 24th, 2017 as a result of the second travel ban order still. So moving on to the Interior Enforcement Order. So there was a lot in this one about interior enforcement, but I'm going to really focus on the things that impacted employers most. The order really outlined everything that the Trump administration wanted to do in terms of interior enforcement. So one of the things that it said was that USCIS was going to begin issuing NTAs again. So for those of you that don't know, USCIS stands for United States Citizenship and Immigration Service. It is the immigration agency that adjudicates immigration benefits from within the U.S. An NTA is a notice to appear from immigration court. So they now said that if your case gets denied at USCIS, they will automatically issue a notice to appear in immigration deportation court, which was not the practice before. So that's a pretty big deal for anyone who actually gets a denial from USCIS. That order also called for 10,000 more ICE officers to be hired. The Department of Homeland Security Inspector General published a report about that in July, and indicated that the Department of Homeland Security has established plans to initiate this hiring surge, but it also outlined the difficulties that the agencies are faced with when they're trying to implement such a huge hiring surge at one time, and indicated that inadequate planning will undermine the department's goals and priorities. So more to come on that and how they're going to make that happen. It also started a new group under ICE called VOICE, that's for Americans who are victims of crimes by immigrants in the U.S. And it was created an office and a hotline for those Americans to call and let the Immigration Service know, or let ICE know what their complaint is, and then maybe ICE will do something about it. So that has in fact been created. There is a hotline that people can call and get help in those situations. And finally, I think the most impactful order on business immigration really is the Buy American, Hire American executive order. This order seemed, it was prospective and unspecific at the time that it came out. It's only about a page and a half long, and it had all these ideas in it, but it wasn't, in contrast to the travel ban, I guess, it wasn't something that had an immediate impact that really scared people to the same level. But now as the year goes on, we're seeing the impact. It called for the Immigration Service to review and reform business immigration with clear goals of protecting U.S. workers and ensuring that higher wages and employment rates for U.S. workers. So as we talk throughout the rest of this presentation, I think you'll hear a lot about how we've seen that really implemented in the day-to-day work that we do. With that, I'll turn it over to you, Eric.
Okay. And just one thing to piggyback on Maria's comment about the notices of, to appear. So it doesn't mean every denial will result in an NTA, but if the denial leaves the person then without a status, they'll be called to immigration court to show cause why they shouldn't be removed from the country. So one of the big things that has happened in 2017 is a massive increase in RFEs. RFE stands for Request for Evidence. Typically what happens is we file an application and then sometime later we get an approval. But sometimes the Immigration Service will say, well, there's not enough information here. We can't make a decision. We need more documents, more information, more detail. And so they'll give us this request for evidence, and we usually have about 3 months to get everything together and file a response. And so RFEs are nothing new. But what's new in 2017 is just a massive increase, and I mean massive, in the volume of RFEs. Sometimes it feels like everything that's filed results in an RFE. Although that's just how it feels. It's not 100%, but it feels that way. The other thing that's different is they're hitting on issues that historically they've never been questioned before. So we're seeing all these new questions come out, and then it seems like they sort of have a hopper of all their favorite questions that they used to issue infrequently, but now they're issuing them, on case after case. So it's keeping us on our toes. The big one is in the H-1B realm. There are two main issues that they've been hitting on all summer. Of course, we filed back in April to get into the H-1B lottery, and then sometime after that, they decided that these were two very important issues that they wanted to follow up on. And so one of them is what we call specialty occupation. In order for an employer to get an H-1B approved for a sponsored employee, the employer has to demonstrate that the job is a specialty occupation, meaning a job that requires a bachelor's degree in a specialty field, such that the employee is applying what they learned in college to their job duties and applying bachelor's level thought and analysis. And so sort of the paradigm example of a specialty occupation would be somebody who has a bachelor's degree in computer science, and then they have a job now as a software developer. They're clearly applying the specialty knowledge that they gained in computer science to their software development job. Or another example is someone who has a degree in actuarial science, and now they're working as an actuary. Other occupations, it's less clear, For instance, if somebody has a business administration degree, and now they're working as a general operations manager, that might not necessarily require a bachelor's degree or a bachelor's degree in a specific field, because there are plenty of people in business who are very successful running businesses who don't have bachelor's degrees, or maybe they have a bachelor's degree in some non-business field. And so historically, we have seen specialty occupation RFEs in certain somewhat limited situations. If a company is small and it appears that the employee is going to wear multiple hats, there's a question, are they really specializing in what they went to school for? Certain occupations in business and marketing, for instance, would sometimes get these specialty occupation RFEs. If an employee was going to be leased out to go work for another company, that might raise a question about what are they really doing. But what we're seeing now with these H-1Bs is a lot, just a very high percentage of cases they're coming back, even if they're software developers or actuaries or clear, specialty occupations. We're still getting an RFE, and then we have to go into great detail proving the connection between the job duties and the employee's background, and why the Department of Labor says this is a specialty occupation. We just sort of have to prove it up in a way and in a lot more detail than we ever have had to before. And if we don't, there is a correlation between these RFEs and eventual denials. So the burden is firmly on the employer to prove these. The other issue that we've seen is level 1 entry-level RFEs. So in order to get an H-1B, the employer has to show the government that they're paying the prevailing wage for the job and that they're paying the actual wage. So there's no circumstance where an H-1B worker can be paid less than what's prevailing or less than what American workers are making for the same job. And so in the prevailing wage arena, there are 4 wage levels, level 1 being the entry level. And there has been a movement in Congress by a few members of Congress to eliminate level 1. So in other words, to say that that a person at the entry level coming out of college just can't get an H-1B. If you pull back and look at the big picture, what that would result in is all the H-1B workers would be managers and senior employees, and all the entry-level people would be American workers. I don't know if that's even the best system, but it's not the current rule. The current rule is all 4 wage levels are eligible for H-1Bs. But the Immigration Service this summer has begun acting as if the rule were that you can't get an H-1B for level 1. So they give us these RFEs and they say, we read your job description and we don't think it's level 1. It doesn't seem like entry level to us. And it's just complete boilerplate language. They say the same thing in every RFE. And then they cite a few lines out of your job description. And so we can overcome these RFEs. We've had good success in doing that. But you have to explain, on the one hand, the job requires a bachelor's level, or requires a bachelor's degree, and on the other hand, it's still entry level. And so that's sort of the needle we've had to thread all summer long for these RFEs. And then the other ones that are on the slide here, L1s, I-485s, and I-140s, we've seen a massive increase in RFEs there too, but we haven't seen new issues emerging. They're just hitting on the same old issues, just at a lot higher incidence. And so, Elizabeth, I wanted to ask you, because I know you've been on the front lines dealing between the law firm and the business units and the employees. With this big increase in RFEs, how are you handling that, and what works for you?
Well, I think what I've done in the last couple of months is I've really put together a rally speech. I've been pulling it out almost nearly every day. And what I'm trying to explain to employees and managers is that this is abnormally normal right now. This is not specific to Aon. This is companies nationally, all over the place, are being hit with these requests for evidence. Also, a key point that I like to tell them is, if your lawyers are asking you for information, yes, you must provide all of the information that your lawyer is asking for, not half of it. And I think what that has done, and I've also explained the longer time frames and just processing in general is expanded right now. The feedback I've heard from people, from colleagues in particular, is that you know, a lot of times they come back to me and say, thanks, that's really helpful. It's made me feel better that I'm not being singled out, that this is not personal, and that, you know, AON is really putting everything that we have behind my case and trying to get this resolved. So it's really just perfecting your little go-to speech and pulling it out nearly every day.
Yeah, right. Okay, so in addition to RFEs, we've seen changes at the Department of State. So, of course, the Department of State operates the American embassies and consulates around the world. And you might have heard of this phrase this year, extreme vetting. It's been in the news a little bit. Although it's everywhere, and I think probably everybody's heard of it, we don't have a clear definition for what it means, not in a legal sense. In press conferences, the president has been asked to clarify and has not really done that. And so although we don't have clarity about what it means, we do know that it's serious. They mean business and they are making changes. And so we can talk about what we do know. And I'll try to give you three main takeaways for extreme vetting based on things that we do know. First of all, back in March, the president issued a directive, and then right after that, the State Department issued 4 cables to every U.S. consulate around the world, and with some guidance around, additional scrutiny and taking a second look at applications and that sort of thing. The State Department also put in a request for a new regulation in the Federal Register and asked for expedited treatment of that. And a lot of what's in that new regulation is shielded from public view, so we don't know what it says. But we do know a few things about it. First, it's right next to where it's going to be placed in something called the Foreign Affairs Manual. That's like the guidebook for visa officers. It's going to be placed right next to an existing program called Mantis. And by the way, I should have said, first of all, there's always been vetting, at least in the modern era. Nobody could ever get a visa without vetting. And so our question with extreme vetting is, what does that mean? What's going to be new, and what are the additional steps and timeline? Mantis has always been part of, or at least since the mid-90s, has been part of the vetting process. Mantis applies when there's reason to suspect that the applicant might be intending to engage in corporate espionage. They're going to illegally transfer technology back to their home government or back to a company, back home. And so whenever there's been cause to believe that there's a risk of that, then the visa officer behaves in a certain way, and they go out and they get what's called an SAO, a security advisory opinion, from one or more security agencies. So the new extreme vetting regulations right next to the Mantis regulation. And if you've worked with government agencies much before, you know that when they come out with something new, they don't usually just invent the wheel all anew. They usually take existing programs and modify and update and pull them off the shelf. And so I think, it's likely that the extreme vetting program is going to be similar to the existing Mantis program. And if that's true, what we know about Mantis is the way it works is, first of all, everyone is sort of presumed to be a threat. And then the only way to get out of that presumption is if the officer thinks, well, this person's clearly not in that camp because of facts and circumstances. So as an example, under extreme vetting, let's say you have an applicant who is an Iraqi national and lived in Iraq during a time when ISIS controlled a portion of territory in Iraq. That's kind of the main paradigm example of the officer saying, oh, this is somebody we got to put into this extra background, this enhanced background check called extreme vetting. And so the way you get out of it is sort of a high burden. The officer has to think you clearly don't belong in that group. And so we don't know yet how that's going to play out. It's just getting set up, so we're going to be watching it over the next year. But that's an example. We know with these SAOs, they also call them technology alerts. When they happen, they can take weeks to resolve because it's beyond the visa officer. They issue this request for an advisory opinion. It goes out to the security agency. It's a complete black hole. There's no transparency. There's no way to know what's happening. You just wait. And frequently these take weeks or even months to be resolved. and then you hear back, and then the visa officer says, okay, we can approve your visa now. And so that's probably what it's going to be, but it's probably going to be limited to people who meet certain criteria, and we don't know what those criteria are, although I think we can maybe take some guesses about it. Number two, in general, for everyone, I would expect to see visa processing delays. One reason I think that is because they are not funding the State Department at the same level as they have historically. And so if you have the same level of demand and fewer officers, it just results in processing delays. The other reason is because under the previous administration, there was a rule that said work visas, the 80% of work visas at any given time have to be processed within 3 weeks. So another way of saying that is if you apply for a work visa at the consulate, you had an 80% chance or better that your visa would be approved within 3 weeks. That rule, that guidance for the consulates has been rescinded by the current administration. So now there's no downward pressure on the visa officers to move quickly. And so the focus has shifted from make a good decision quickly to we don't care how long it takes, just make a good decision. And so that's, I think, goes under the heading of extreme vetting. Those are two things that we can't really affect. There's not much we can do to lawyer. If somebody's got something in their background that's creating a question or a problem, you know, it is what it is. But the third thing that we really can do, and this is where we can make a big difference, is in making sure that our applicants are prepared. Because in addition to these enhanced background checks, the officers are also just scrutinizing things more closely during the interview. They might be asking more questions or more pointed questions, or they might be looking at the documents more closely. And so where we can have a real impact is making sure before our folks go in for a visa interview that they understand the point of the visa interview, that they've got all their materials and documents, that they have a clear understanding what questions are likely to come up, and that they've thought about their responses, that they just go into the interview feeling confident about it so that they can go in and do a good job advocating for themselves. And that's where we come in. In my own practice for quite a while now, I've done, I or people on my team have done a prep session with everyone who goes in for a blanket visa, and that dramatically increases the approvability rate. And as we look to the future, we might be doing this with more visas, more situations in every consulate, not just difficult consulates. We might also be doing it with respect to adjustment of status interviews here in the United States, which I know Maria is going to talk about in a little bit. So I guess the third point then is just be prepared before the visa interview. And then Maria is going to talk about changes at USCIS.
Great, thanks, Eric. So as I mentioned before, USCIS is the benefits granting immigration organization from within the U.S. It's part of Department of Homeland Security. There are sort of two levels of benefits they grant. One is non-immigrant benefits, and the other one is, of course, green card applications. Non-immigrants are the visas, so H-1B, L-1, O-1, all those crazy letters you hear us say. The first thing that's worth mentioning about CIS is that CIS has a new director. The new director was sworn in on October 8th of 2017. He has a clear priority of policing abuses and preventing fraud. On October 20th, 2017, we saw a new memorandum regarding no more deference for H-1B or for non-immigrant petitions in general. So there used to be since 2004, and then it was again restated in a memorandum in 2015, that if you filed an immigration petition, a non-immigrant petition with essentially the same facts, so for example, an H-1B for the same employer, same job, same beneficiary, that the Immigration Service would give you the benefit of the doubt that, okay, we approved this before, nothing's changed, we'll approve it again. Now that's not happening anymore. They're going to look at each petition individually, so we should expect a higher level of scrutiny on extension applications. Another thing that you probably all heard about if you deal with immigration is that premium processing was suspended for a large part of this year. And for businesses, that's really a big deal because a lot of businesses rely on premium processing to be able to have their employees on the timeline they need them, or if you need employees to travel along, a lot of times you need to premium process an H-1B petition. The reason that CIS suspended premium processing this year was because they found themselves in a situation where they had such a huge backlog of H-1B petitions that they just couldn't get to them in a timely manner, and having premium processing was making that worse. So regular H-1B petitions that weren't premium processed were taking almost a year in some cases to be adjudicated. So they suspended premium processing. They worked their way through a lot of those petitions, and that part I would say has mostly been a positive. We've seen things speed up quite a bit, and they have now reinstated premium processing for all H-1Bs, which is great. But at the same time, as Eric was talking about before, they've increased requests for evidence, which has really, again, increased their burden and increased the amount of work they have. So we don't know what's going to happen for H-1B cap season this year, whether they're going to suspend premium processing again or not, but I won't be surprised if they do it given the current workload that they have. Under the green card applications, there have been two major changes. One is a policy change on advanced parole. So advanced parole is temporary travel authorization that you can apply for when you're filing an adjustment of status green card application. Anybody who has an H-1B or L-1 non-immigrant status in the past was always able to travel with their H-1B or L while their green card application and advanced parole application was pending. Now, if you travel while your advanced parole application is pending, the advanced parole application will be denied. So it's not to say that if you have an H or an L, you can no longer travel during the green card application process. You can, but we should look at all of those cases on a case-by-case basis and decide whether do you need that advanced parole, or is it better not to have it at all and just travel on your H-1B or L, or do you really need that advanced parole because you might be running out of L time, and that's really what's going to keep you having the ability to travel. So you might want to file the advanced parole, but then know that you need to stay in the United States while it's pending. And the second thing that's a major change for green card applications, that employment-based green card applications are now interviewed. So in the past, most of the employment-based adjustment of status applications were processed at a national service center unless there was a red flag or a reason that the Immigration Service felt that that individual person needed to be interviewed. Now they're going to, or they have already started transferring all the I-45 applications from the National Service Center to the local offices to be interviewed. So we expect that that's going to significantly increase the processing time for green card applications because they haven't increased the staff or the resources at those local offices. So all of a sudden the local offices are getting a huge influx of new files to review and interview, but they're not getting any additional resources. So the impact on that is extended processing time. The other impact on that for businesses is that you should really be careful and think a lot about foreign nationals who are changing jobs as part of the green card process, or in the middle of the green card process. That should also always be something that we're discussing and talking about, because it may impact the green card application, and that foreign national may end up in a situation where they actually have to explain that to an immigration officer, and we of course want to make sure they're well prepared. So when we start getting those employment-based green card interview notices, we'll certainly be talking to clients on a case-by-case basis on how to handle it, how to prepare, and what to say during the interview. The other thing that happened was there was an audit of the FDNS site visit program. That's a USCIS program where immigration officers have for many years actually been coming to employers to verify that the information that was filed in the petition with USCIS was in fact accurate. So they show up randomly at your office and they want to speak to whoever signed that H-1B petition and the foreign national themselves, make sure the foreign national is there, actually working in the job that they said they were working in for the salary that the employer said they were paying. On October 20th, the USCIS Inspector General announced that the current site visit program is no longer effective and that USCIS should improve it by better tracking site visit activity and then better leveraging the data. It also recommended creating a new career path for officers who want to specifically focus on fraud. So practically, I think that means we can expect some changes to that site visit program. It's not going to go away. I expect it to be enhanced. So if you don't already have a plan for how your company handles site visits and who the receptionist should call if a USCIS officer shows up, certainly let us know, and that's something you should have in place. And then the final point is just processing times. Processing times have significantly increased across the board for all types of applications, which is problematic for us.
So by comparison, the Department of Labor, things have been pretty good. They have new leadership over the last 2 or 3 years, and that new leadership has really done some cleanup work, and they are functioning very well. So it'll only take a minute or so to talk about their changes. One recent change is, for many years, when an employer files a perm application, then they get an email asking them to confirm sponsorship, and that email then had to be responded to in 7 days, or you would lose your application. That was not convenient, because if you happen to be on vacation when the email came through, you might miss your window. So they increased it. After 11 years of asking them, they increased it to now 30 days. So that makes things a lot easier. They also took a hard look at their audit process. They used to issue these audits, and the response would just be like a telephone book of paperwork that you had to send back. And most of it they already had, and they didn't even need, it wasn't even relevant to the decision. And so they said, well, this isn't necessary. So they reduced it down, and now an audit response is, maybe 30 or 40 pages, and we can submit it online through their electronic system. And so it's just a lot more user-friendly. And then finally, the other thing they've done is they have caught up their inventory of pending applications to match their staffing level. So now prevailing wage determinations are taking about 78 days. Perm applications are taking about 4 months. Unless something unforeseen happens, they have indicated that they expect that that processing time frame to stay about the same into the foreseeable future. So on to DACA. This has been big in 2017. DACA, for people that don't know, is the program created by the previous administration for people who were brought here to the United States illegally or legally, but then their status expired and they continued on as children. And then now they've grown up and they don't have a lawful status or a way to go to work. And so Congress has never been able to come up with a program for people in this situation. And so the previous administration created DACA. It was a guarantee to people who qualify. Basically, they were brought here as children, now they're adults, they graduated from high school and they don't have a criminal background, then they would qualify. And it was a guarantee that they would not be deported simply because they were here illegally. They'd have to do something else, like commit a crime or something, to be subject to deportation. And they could also get a work permit so that they could legally work. The current administration in September rescinded DACA and put it on a path to elimination. And so what that meant was in the period between September 5th, when the announcement was made, and October 5th, people who had a DACA work permit and were eligible for a renewal had to file for their renewal application in that 30-day window. We're now past the 30-day window, and so people who have a DACA work permit, that permit will eventually expire, and then they will have no basis to work in the United States. They also no longer have any guarantee that they won't be deported. And so being that there's a lot I could say about DACA, but since this is a business immigration seminar, I'll just confine what I say to, from the employer perspective, what do you do? We know that there's about 800,000 DACA work permits, individuals with DACA work permits. So that impacts a lot of employers across the country, and some employers are heavily impacted by it. First thing to think about is this is primarily an I-9 compliance issue, because like any employee, an employer has a federal obligation to verify the work authorization and the identity of its employees. And so if someone presented a DACA work permit and it's now going to expire, when you get close to that expiration date, the employer has a duty to go back to the employee and ask, do you now have a new basis for work authorization? If they don't, and unfortunately most people in this situation will not, then the employer is obligated by law to terminate the employment of that individual. Some companies have been openly talking about not complying with this law and what would the penalties be if you don't comply. And I think that comes partly because it's so disruptive to businesses, but also partly because there's a lot of sympathy in this area for the people who are going to be in this situation. And so I would have to say I don't recommend anyone intentionally not comply with the I-9 rules. And the reason why is because ICE has made some statements recently that if they do an I-9 investigation of an employer and they find evidence of a program, an intentional policy of disregarding the I-9 rules, that they will pursue the employer for a pattern and practice of noncompliance. And so in the I-9 world, you normally have civil fines for noncompliance, but if it's intentional and part of a pattern and practice, then it moves into criminal sanctions. And so what would happen in that scenario is, at least potentially, is ICE would refer the matter to a U.S. attorney for criminal investigation. And so companies who are contemplating just not complying with the rule are really taking, a considerable risk. What we're hoping for is that now that this DACA program is on the road to extinction, that Congress will act. They have until March to act and create a legislative remedy so that people in this situation can at least have a work permit again. And members of Congress are working to try to get it into the budget on the theory that the budget, the administration is not going to want to veto the budget over DACA. And so that might be a way to get it in. Otherwise, it'll go into 2018 and we'll see what Congress comes up with. And then one final point, DACA applicants had an understanding from the government that the information, their names and addresses and things like that they put on the application in order to get the work permit, that personally identifying information wouldn't later be used for enforcement purposes. But now we have a new administration and it's not clear that that's still true. And so some senators wrote a letter to the Department of Homeland Security and asked them for clarification on the policy to make sure that the data in the work permit applications is not being shared with law enforcement and with ICE for purposes of deportation. And there hasn't been an answer yet back from Homeland Security that I'm aware of anyway. So with that, Elizabeth, I know you guys have, like every company, have been thinking about DACA, and maybe you could talk about that and then also talk about just some general practical changes.
Sure. So for DACA, I think we kind of had a sense that this year that the cancellation might be in the works for this year. So pretty early on in 2017, we wanted to get an idea of how big of a population this was at AON. We also wanted to see which business units might be affected because, it could be a disruption to our work. So we worked with, the law department worked with HR operations, and HR operations does all of our I-9 work. We worked with them to kind of collect all the EADs in the last number of years, and then really it was a manual process of looking at every single EAD and figuring out which ones had the DACA code, which is C33. It sounds worse than it actually was, so don't be scared if you're thinking about doing that. It was a fairly small number. And what we were able to do with that information is to go take it back to our leaders, and they worked with the HR leaders to figure out a strategy on what level, how we're able to assist these colleagues. We wanted to, we don't want to use that information, I guess, in a discriminatory way. We are actually, trying to collect this information to see which pockets or which business units might be affected more than the other ones. And it was fairly widespread across all of our businesses. But it was really a collaboration, I would say, between the law department and HR to get that information quickly. Hats off to the operations team. They did a wonderful job.
Mm-hmm. Okay. You want to take the next slide, Judy?
Sure. So Eric and Maria asked me to talk about some practical adjustments that we've been making at AON. There's a number of them that I thought I would share with you. We're really looking at that level 1 wage for our labor condition applications. And for what that means for us is collaborating with our compensation group to understand a little bit more about how wages are allocated and what the thought process is behind it and what the methodology is that they use. So we are certainly looking at our level 1 wages closer than we ever have been before because of that increase in RFEs. We did a pretty significant self-audit of our public access files. It took, I'll be honest, it took a number of sessions to get that all done because frankly, we have a lot of public access files. And it in practical terms, that meant locking us in a room, closing the door, not having our computers, and just looking at each file. It was really, you really had to roll up your sleeves and just put your head down and do it. But the outcome is, I was telling my boss, I said, our public access files are in great shape. So the outcome was, as we came out of that, very, very confident. And we also are able to, we also just reorganized them and made sure that they're all housed in a central location. Premium processing. So on a case-by-case basis, we are using premium processing, I think, at a higher clip than we ever have before. Couple advantages for premium processing is that you get a little bit, obviously you get faster service, but you get a little bit better customer service. So if there's any sort of issue on your approval form, you have access to the premium processing unit. There's an email that you can access them. So we've been just using it quite a bit more. We are also finding that it helps move our docket along a little bit faster. We're still dealing with last year's H-1B CAP cases, which we've never been in that position before, where you'd be dealing with that in November. So we're hoping to clear all those out so that come to next year's CAP, we're just looking at next year's cases. And then a couple of other things is we're just asking employees to contact us every time they travel abroad. I would much rather spend a couple of minutes looking at their email and looking at the documentation and responding than to be in a situation where they're stuck outside of the U.S. for some reason and having to go back to the manager and having to explain that. It takes us, just a couple of minutes to look at those materials. And we are also, what we kind of touched on before is just socializing more with HR partners, managers, and employees of these very long extended processing times. What I said earlier, abnormally normal, what used to take a couple of months is now taking 6 or 7 months. And just asking for people's patience and letting them know that we really are doing everything that we can for them.
Thank you. So we have one slide left, and it was about some predictions about 2018, but I know we're getting very close to the end. If anyone has questions, we're happy to take the questions. And if not, we'll spend our last minute or so talking about the okay, what is the grace period for an H-1B? Who is denied, and what is it if he is terminated for cause? So under the new rule that Maria talked about that came out in January of this year, there's now a 60-day grace period, meaning if somebody has an H-1B and they suddenly lose their job for any reason, even if it's for cause, they are granted 60 days of grace after they stop working. It used to be immediately, the next day, you were immediately out of status. Now you have 60 days. That gives the employee a chance to find another job and apply for a change of employer, or to exit the country, or to change their status to student or visitor or something like that. And so it applies even if they were terminated for cause. So are there any other questions? If not, I think we're out of time. So we have this slide on 2018, and if anybody wants to give me a call, I'm happy to talk endlessly about what I think is going to happen in the coming months and years. Thank you, everybody, for attending.